Hi there, and welcome once again, Employment Law Show. Good to have you along for the entire show. You're going to learn lots. John Scholes here, along with co-founding partner Samfiru Tumarkin LLP, the most positively reviewed employment law firm in the land. So you know you can trust them. You know you can reach out anytime. How do you do that? We'll throw it up on the screen during the show, but I'll give it to you right now. 1-855-821-5900. help@employmentlawyer.ca. On the show today, 5 facts about temporary layoffs. You need to know this, especially in the climate we're in, right? We'll get to that. Some phone calls from our radio show, some emails and other correspondence from viewers and listeners we've had over the last couple of weeks. So that is all coming up. But first, Lior, we always start with the week that was, pal. What do you got going on?
Well, another tremendously busy week in my office. You know, it is every time I think we hit a certain milestone, we just smash it and move right past it. But it's good because on this show, like I do in my office, we talk about workplace rights. Your rights are still here. I know it's easy to think we live in a time when the rights are violated or there's no rights. Not true. You have rights. And employment law is still here to protect you. It's always been here. And what we do on this show every week is to talk about those rights that you have. What happens if you're facing a vaccine mandate? What happens if you're facing another sort of ultimatum? If you lost your job, if you've been put on an unpaid suspension, unpaid leave? What happens if you're mistreated or harassed in the workplace? We touch on all these things right now. We'll tell you what you need to know. But of course, you may have very specific issues or questions that we can't get to on this 30-minute show. Not a problem. All you do is you reach out to me in the office. Let's have a private chat, phone, email, whatever you want. We'll give you that information throughout the show. But I want you to remember that the law is here to protect you. In this country, we have really good employment laws. We're going to tell you exactly how those are, what those are, and how they work. And to do that, John, let me start with a situation that came across my desk over the past week. So we've all heard about the vaccine mandates. We've all heard about employees where their job is threatened because they're not vaccinated. So let me tell you about such a situation that crossed my desk very recently. I spoke with a gentleman who dealt with an employer that gave him an ultimatum. You have to get vaccinated by a certain date, or if you don't, then we're not going to be able to have you work here. He thought about it, decided for his own reasons. I didn't even get into the reasons. He's not getting vaccinated. He told his employer. His employer pushed back a couple of times, and when his employer realized that that's not going to change, all he did is said, okay, well, we implemented a policy. You decided you're not going to follow that, so we consider that to be a resignation. You've resigned by saying that you're not going to get vaccinated. Here's your record of employment. We wish you all the best. Feel free to apply in the future. So this person called me, and he wanted to know, well, wait a second, is this a resignation? I'd rather be at work right now. Yeah. The reason I'm not at work is because my employer told me not to be. So that's exactly the right answer. It's not a resignation. If ultimately you lose your job because you don't get vaccinated, that is a termination. It's your employer deciding to let you go. It's not you deciding you're not going to work there. It's not a resignation. The only one that can decide if you're going to leave is you. A resignation is something that you do voluntarily and unilaterally. If your employer says you're not here, that's a resignation. Nonsense, ridiculous, illegal. That's a termination. And the reason why that distinction, John, is important between resignation and termination is because with a termination, you get severance. And that severance can be as much as 24 months. That's with a termination. With a resignation, you don't get anything. So why would you agree to walk away from rights that you have? So in this particular situation, this person was terminated. In the eyes of the law, that's a termination without cause. He'd been with that employer for 11 years. He's owed right around a year's pay, potentially some other damages as well. So I wanted everyone to remember that. If you lose your job, whether it's because of vaccinations or for any other reason, if it's your employer deciding you're not going to work there, that is not a resignation, can't be a resignation, that's a termination.
Some people still have that mindset, though, when they say, you know, I'm going to give you a choice. Either you're going to get let go or you're going to resign. They think, oh, well, I'd rather resign. I don't want that, you know, permanent record showing that I was let go from my job. This is much safer to just say I've resigned, right?
There's this perception that it's better to have resigned. It's better that somehow you're marked as resigned rather than be let go. So let's be very clear. There is no reason ever why it's better to have resigned. There's no database that's available where someone is recorded as having resigned or being let go. No, the only thing you can accomplish by resigning is to walk away from rights that you have, to walk away from severance, from other compensation that you are owed. So sure, if you've decided you don't want to work for a company anymore, if you've decided you want to do something else, that's great. That's a resignation, no problem. But if it's the company deciding that, don't give them an out. Don't allow them to save money on entitlements that you otherwise have. It's not better to resign than to be terminated.
You know, I think there's still some confusion based on what you were talking about with your week that was when it comes to this whole mandatory vaccine and the government mandating this. There's a difference between a government mandate and working for the federal government when it comes to having to vaccine, right? Get the vaccine. Where's the rub?
Yes. So the federal government has announced that certain individuals that work for the government in certain core positions will have to be vaccinated or they can't work there. So if you work for the government in one of those core positions, if you don't get vaccinated, unfortunately, you can be let go without compensation. But if you're federally regulated, that mandate does not apply to you. For example, if you work for a bank, if you work in trucking, if you work in telecommunications, there's no mandate, there's no government mandate that applies to you. So in that situation, if you do lose your job, if your employer decides, we're not going to have you here because you're not vaccinated, that is a termination. That is a termination without cause in the eyes of the law. And yes, you have to get severance.
You want to go to the website, employmentlawyer.ca, for contact, of course. Lots of things to be learned on the website. You can also follow along and find a radio station near you that carries our long-running radio show. It's been almost a decade that we've been doing that. Tons of information, lots of phone calls on the show. We play them back here, and we dissect them. We talk about them. Phone call number 1 from our radio show is coming up now.
I am a professional software salesman. I work for a Canadian subsidiary of an big American software company. 5 years in, I have a base salary and a commission, always made my numbers, my quota, and they have just told me that they want to double my quota and give me a national sales territory. I have to sell twice as much as I previously did to make the same amount of money, and it's kind of take it or leave it.
That's not nice.
It's not nice, and it may be one of those situations where it's better to leave it instead of take it. And here's what I mean by that. Hopefully our regular viewers know what I've said before, that an employer cannot make significant changes to the terms of your employment. That results in a constructive dismissal. Well, a constructive dismissal also happens if your employer, what it's actually doing is changing the form of compensation or the compensation structure. So you were on commission, they eliminate that, or you were on salary, they add commission, or they change the commission structure so you really can't make the same amount of money. Well, if any of those things happen, the words constructive dismissal should come to mind. It's not something your employer is allowed to do. So one of the options that this person has, the caller that we just played, is he can choose to say, no, I'm not agreeing, and if you're going to do that anyway, employer, I'm going to treat that as a constructive dismissal. Now you have to pay me severance. Now, there's a couple of reasons why that's a good idea. Other than the obvious, which is he's not going to now make less money, is the fact that if he allows this change to happen, well, guess what? Next year, if they double his quota again, and the year after when they triple his quota, he won't be able to do anything about it because he let it happen that first time. That's why it's so important. When it comes to changes to terms of employment, not to just accept them. By accepting them, you give the company the right to do it again. So, John, we know that this person has been constructively dismissed. The question then becomes, what is he owed? What is severance for him? So I'm going to tell you right now, and you can find out yourself in your situation. All you do is you go to pocketemploymentlawyer.ca. So let's take this person's info, let's plug it into the pocketemploymentlawyer.ca tool, and let's see how much severance he's owed. So we know he's been there for 5 years. He's in a sales type of a role. He hasn't been offered any severance because his employer said take it or leave it. Well, we can see at the bottom of the screen that he's owed as much as 10 years pay, somewhere between 8 to 10 years. Okay, 8 to 10 months. It would be nice if it was years.
No kidding.
8 to 10 months pay. Now, depending on his compensation, obviously, that's going to be a significant amount of money. Now, John, this is someone that has not been let go.
Right.
His employer didn't say you're out of here. This is someone that's been constructively dismissed, and because of that, he's owed severance. Same thing may apply to you.
Now, this one's obvious. He's taken a massive haircut, but if it was like, 6 of one, half does the other, maybe it's not a big change. Maybe I could make less money, just by a bit, or maybe more money. Could you try it and be safe that if you don't like it, you can turn back the clock and say, no, this didn't work out like I hoped it would. I'm not doing it permanently.
Yes, there's the ability or the possibility to try it out to see how this impacts you, especially if it's not clear how the change is going to impact you. They may say, well, we're going to double your quota, but we're going to bring you so much more business that it's not going to be a problem. So you can tell your employer, hey, employer, I'm not comfortable with this. I don't know that I'm willing to do it, but I'm going to try it. I'm going to try it for the next few months, see how it goes. And then if it's not going properly, if I'm taking less money home, I'm going to treat that as a constructive dismissal. Make sure that's in writing. Make sure it's only for a relatively short period of time. If you do that, yes, you can try things out.
You want to reach out another way to Lior and his team, terminationquestions.com. That's a great resource. Ask your questions, get them answered. We'll get to one now, Lior, before the break. Lee writes in, says, another company is buying my current employer. What happens to my years of seniority built with the original owner?
It's another common question that I get, John, and here's how this works. If a company that you work for is bought out and you continue working with that buyer, well, your seniority carries through in most cases. So let's say you work for 10 years with the old company. Now on day one with the new company, you're a 10-year employee. They inherit your service. But, and this is important, in some cases what an employer may do, that the buyer may have you sign an employment agreement that eliminates your prior service. Very bad idea. You want to watch out for that. So if they hire you on the handshake, say start Monday, great, good news, perfect. If they want you to sign a 5-page document, read that document very carefully. I can almost assure you that somewhere in that document there could be a term that tries to eliminate your prior service. But if that doesn't exist, they inherit your service, meaning if they ever let you go, the severance they have to pay you will account for the time you spent with the previous company.
All right, a lot to digest there in the opening few minutes. We'll take a short break and back to this. 5 things you need to know about temporary layoffs. That is on the way. In the meantime, 1-855-821-5900, help at employmentlawyer.ca as well. We're continuing employment law show. Stick around. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back. Employment Law Show here. John Scholes, Lior Samfiru, co-founding partner, Samfiru, Tumarkin, LLP. Reach out anytime to the most positively reviewed employment law firm in this land. How about that? 1-855-821-5900 is the way to reach out. Help at employmentlawyer.ca. Okay, pal, as mentioned, 5 facts. We could have done 55, but we're going to narrow it down to 5 facts about temporary layoffs. This one is a big one, always in question. Temporary layoffs are illegal, yes, even during a pandemic.
So some people right now may have dropped their coffee as they're watching this in the morning because they're thinking, well, wait a second. Like, I've been on a layoff for many months. A bunch of my friends have been on a layoff. How can you tell me that it's illegal? Well, guess what? It is. Despite the fact that we've heard it all, that during COVID, so many employees have been put on a temporary layoff and a leave of absence because of COVID for legitimate reasons. It does not change the fact that a temporary layoff is not something an employer just automatically is allowed to do. Meaning, if you've been put on a temporary layoff, because that layoff is actually not allowed, you can treat that as a termination. You can do that on day 1, you can do that on day 101, you can do that whenever you want to. The choice is yours. So if you've been put on a temporary layoff, ultimately, you have to decide, do I accept it, stay home and hope for the best, or do I choose to treat that as a termination and get my severance? Even during COVID, It's not legal, it's not appropriate, it's not allowed to put an employee on a temporary layoff.
And that is point number 2. Even before day one, if you know it's coming down the pike, you could say, no, I don't accept it. I'm going to call that a termination. Treat it as such, right?
A lot of employees ask me, well, when does it become a termination, or how long do I have to wait? So let's be very clear. You don't have to wait. Because, as I said with point 1, you don't, an employer doesn't have the right to put you on a layoff, meaning once they do, they've done something inappropriate. So if you've been put on a temporary layoff, you can choose now or later to treat that as a termination. What some employees have done, John, is they said, well, I'll wait a little bit and see, because if they call me back within a week, it's fine, I'll accept it,
right.
Fair enough. But if it's been a while, if you're still not back to work, I've been speaking with people that have been off work since beginning of COVID, a year and a half, going on 2 years now, and they haven't been called back. Well, guys, enough is enough. I think at some point, get your severance, move on. If that's what you want to do, let's talk about it.
And if you do that, you call their bluff and say, no, I'm not going to a temporary layoff, you will get severance because it's a termination. That can be as much as 24 months. Most people surprised by that, right?
A very important point, because some people may think, well, okay, if it's a termination, as Lior said, and I'm owed severance, if they only have to pay me 6 weeks or 8 weeks, well, it's not worth that. I may as well stay at home and wait. Fair enough. It's not that. Severance can be as much as 24 months' pay. And you can find out right now in a few seconds how much severance you're owed. Just grab your smartphone, tablet, desktop, what have you. Go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You'll see our severance calculator tool there. Once you click on that, you can answer 3 questions in seconds, find out how much severance, how many months of severance you're owed. Free and anonymous and easy to use. Check that out for yourself. It may be a lot more than what you realize, and that applies whether the company lets you go, whether you've been constructively dismissed, or whether, as we've been talking about, you've been put on a temporary layoff.
We were talking about the 5 things or at least 5 things you need to know about temporary layoffs, and this one's important too. You always talk about this. It's always, what happens if, and that is if you accept the temporary layoff, say, okay, I'm a company guy. I'll just, I'll suck it up and grin and bear it for a while. The problem is if you do that once, they can do it again and do it again and again, and you can't do anything about it, right?
Isn't that an awful situation to be in? So I've said now that it's not allowed. You're not really, employer's not allowed to put you on a temporary layoff. But if you allow it to happen, if you accept it, even though you didn't have to accept it, but if you choose to accept it, by accepting it, you've given the company the right to do it again. So here's a situation you can find yourself in if you've accepted this temporary layoff. You are on the layoff, you go back to work, you work for a few months, then you're laid off again for a few months, you go back for a few months, back and forth, back and forth. That's not a good way to work. It's not a way to earn a living, because we all need to earn a living, which is why I caution everyone from accepting this temporary layoff and creating this implied term that your employer can just lay you off temporarily. It may be better to say, no, I am not opening that door. I am not creating that precedent. I just want my severance and move on to a different job. For many people, especially if you've been off for a while, that may absolutely be the best option.
The 5th one is this, Lior, and if you are one of the lucky ones that does get called back from a temporary layoff, they got to call you back from what you left. They can't change your location, change your duties, change your pay, all nights to days, all that stuff. It's got to be what you left at the beginning, right?
So before the break, previous segment, we talked about this concept of constructive dismissal, the idea that your employer cannot change the terms of your employment in a significant way. They can't reduce your pay, they can't change your shifts, your hours, they can't demote you. Well, the same thing happens if you come back from a temporary layoff, meaning if you've been off work and now you're back to work, if your employer says, we'll bring you back but to a different shift or a different pay or a job, well, you at that point can still say constructive dismissal. If they don't bring you back to the same role, that's a constructive dismissal. Again, gives you the right to treat that as a termination and get severance. And you don't want to accept the change. Remember, anytime you accept the change to terms of employment, you've given the company the right to do it again and to make it worse down the road, something you really have to keep in mind.
Again, the website, employmentlawyer.ca, for all things about what we talk about on the show, reaching out with contact information as well. And to find a radio show near you that plays our radio show probably several times a week for the last few years, so you can tune into that. We'll get it to another call, Lior, from our radio show right now.
I'm just wondering if all employers are obligated to provide severance packages, or are there any reasons maybe some small company is exempt? When you're negotiating a severance package, can something like pension and benefits be negotiated?
These are all great questions because a lot of people assume it's a little mom and pop shop. They don't have to pay severance. They're too tiny.
Absolutely, and that's completely false. Let's be very clear here. The size of the company, the size of the company's payroll, the number of employees does not impact the severance that you are owed. The main factors are your age, your position, and the length of your employment. So it's about you, it's not about the company. Now, your minimum entitlements may be different depending on the size of the company, but that doesn't matter. Your full entitlements, which is all that matters, are the same. Big company with thousands of employees or tiny company with one employee. If you lost your job, you are owed severance as much as 24 months pay. Very important to remember. Now, the other aspect of this, remember, when we talk about severance, it's not just salary. It's all components of your compensation. So salary, of course, but benefits, bonuses, car allowance, pension, gym memberships, you name it, that's all something that has to be included as part of the severance package. So if you're just being offered severance based on your salary, no, that could still easily be a wrongful dismissal because all other components have to be accounted for as well.
2 quick questions. I'm part-time. Do I still get it? And I work on sales and commission. Goes like this. How do you calculate it?
It does go like that. That's good. I like that. So let's be very clear. If you have a job, full-time, part-time, on contract, temp, whatever it is, if you lost that job, you are owed severance. You are. And again, we talked about pocketemploymentlawyer.ca. It works just as easily whether you're full-time, part-time, or any other role. So check that out for yourself. Now, if your compensation varies, you don't always get the same amount every check, every month, not a problem. Your severance is going to be calculated based on your average earnings. Depending on how long you've worked there, maybe we'll look at a year, maybe 2 or 3 year average. And if on average, everything considered, you make $55,000 a year, that's the figure that's going to be used to calculate your severance. Not very difficult to do.
Want to take a short break, get up to another phone call on the other side, but we gotta pause for a moment. 1-855-821-5900. Any time to reach out to Lior and his team and help at employmentlawyer.ca. We'll continue Employment Law Show. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. As mentioned before the break, you go to employmentlawyer.ca to find a radio station near you that carries our show. It's an hour-long show, several times a week. Lots of information, lots of phone calls, lots of listeners, and you can become one of them. Phone call number 3 from the radio show is coming up right now.
I was employed close to 5 years with the company. Started a side job, kind of like a side hustle on the full-time employer, found out about the side hustle, essentially set up a setup or a sting in order for me to sort of catch me doing a side job. And I was doing this all outside of company time. And then I was eventually terminated due to have a second job. Is that something that's allowed? Can I do that?
This side hustle, was it in any way competing or competitive with your main employer's business?
No, totally unrelated.
Never like a sting operation. That's good.
That's kind of cool. Eh? Very interesting. I remember that call from our radio show. So let's be clear on this as well. So ultimately, if you're not doing something that conflicts with your employer's interests, if you're not competing with them on the side, you can't do that, of course. And if you're not you're not spending time on your second job while you're working for your employer. You're not stealing time from them. You're doing it on your own time, evenings, weekends. It's not a problem. You can have 2 jobs, 3 jobs. A lot of people, especially these days, hold multiple jobs. Right. And the fact that you're doing that does not mean you've done something wrong. Now, on the other hand, if you're spending time when you should be working, doing something for your side business, or if you're competing with your employer on the side, they don't even know about that, that's a problem. So, but in this particular situation, the call that we've heard, no, that's not misconduct. He's done nothing wrong. Meaning, if his employer wants to let him go, they are allowed to let him go. An employer can let someone go for any reason, pretty much. They have to pay him severance. It's not just cause. It's not misconduct. It's not inappropriate what he's doing. So no, that's not something that an employer can do. And you remember yourself, I always think it's a good idea to tell your employer if you're doing something on the side so that there's no confusion about what's happening. But ultimately, it's perfectly common and appropriate to have more than one job, and it's not something you can be punished for.
You think of how many people are doing some sort of ride-sharing program now, an Uber or a Lyft on the side. It's got to be in the tens of thousands of people, but they might have other jobs.
Most of them do, in fact, and that's not uncommon. And even beyond that, you know, a lot of people, to make ends meet, especially now, difficult times, have to hold the second job, some even a third job. And that's okay. That's not inappropriate. It's not illegal. And your employer can't punish you for needing to earn a living.
We'll take one more kick at terminationquestions.com. That's a website you can ask your questions on anytime as well. This one from Tanya. And she says, the company just cut my job after 17 years because of the pandemic. My severance offer is for 26 weeks. Should I accept it or check with the government first to see if I'm owed more? I'm 48 and had a salary of $64,000.
So the question she's asking, should I accept or should I contact the government? Well, why isn't there a third option? Because neither of those options are even close to being appropriate. So let's start with accepting it. So if she's been there for 17 years, again, I don't know all the specific, well, actually I do know she's 48 years old. She probably is owed 14, 15 months pay. Right. So let's say 15 months pay, she's been offered 26 weeks, that's 6 months pay. So obviously she's owed a lot more. So accepting it, we're gonna cross that out. That's not an option. Yep. Well, her second question is, should I and can I contact the government in this situation? No. The government can only advise you or help you with respect to your minimum entitlements. Now, her minimum entitlements may be as little as 8 weeks pay. Her full entitlements, as I said, is 15 months. So when it comes to losing your job, when it comes to your severance, your termination entitlements, you cannot go to the government. They cannot help you with that. For that, you need to speak with an employment lawyer. If you don't like me, that's okay. Speak to another employment lawyer. But that's what you have to do. Now, if you have an overtime issue, a vacation pay issue, yes, absolutely. You can and you should contact the government. Not if you lost your job. So for this lady, no. Don't accept 6 months when you're owed 15. Don't call the government when they can't help you. Get some advice. The good news is these types of issues, to get it from 6 months to 15 months, not difficult, not time consuming, not expensive, so definitely worth doing.
If she makes that phone call to the government, what's the answer she's going to get, most likely?
She may be told, well, you're only owed 8 weeks pay. They offered you 26. My gosh, what a wonderful deal. So she'll think, okay, I'm going to accept 26. The government told me that's a good deal. When in fact, as I've said, she's owed 15 months pay. That's why, again, I can't repeat this enough because this happens every day. If you lost your job, you cannot, should not ever contact the government. Doesn't matter what province you're in, doesn't matter what you've been offered. Go to pocketemploymentlawyer.ca. Frankly, the easiest way to find out in seconds how much you're owed, at least get an accurate assessment. Pocketemploymentlawyer.ca. We have our handy dandy severance calculator tool there. That's what you have to do if you lost your job.
Any final words in the last minute about people still struggling with COVID and worried about vaccines and going back to work because it's not over yet, right?
So here's what I want to say about vaccines. This is important. The reality is a lot of people have questions about whether or not it's legal or not. I don't focus on that. I focus on more practical issues. Even if your employer's vaccine policy is not legal, if you don't comply with it, you will lose your job. It's a fact. It may be illegal, but you will still lose your job. So the question is, what are you owed as a result of losing that job? And you have to ultimately decide what is better for you. Is it better to get the vaccine and continue working, or not to get it, lose your job, and then deal with compensation? That's a personal decision. I don't advise on that. if you do lose your job, if you are suspended, you have rights in most cases. You need to give me a call as soon as possible in that situation.
And that is it. We pack a lot into 30 minutes, so you want to reach out. Here's how you do it. 1-855-821-5900. help@employmentlawyer.ca, the website, and terminationquestions.com as well. Free and anonymous. Go ahead and use that. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.